Thank you, Sharmaji, for having me here, for persistently following up on the list of cases and for everything, and for reminding me every now and then. I'm grateful to you that I could also make it. To the
Thank you.
President, Shri Vipul Choksi ji, thank you. Thank you to the other members, Mr. Sangvi, Mr. Salva, Ms. Maitri, the chairperson of the IT committee. The list of decisions, I must confess, has been chosen purely out of my convenience because, and you will notice one common thread throughout these decisions is that I have appeared for the revenue in almost 90% of these cases, either in the High Court or Supreme Court. So please don't assume that these decisions have been listed out as a chest thumping exercise by me here. It has been listed out sheerly out of laziness because I will not have to put in too much effort while preparing. And also, I will be able to share snippets of how the decision making process happens and is arrived at by the courts, which will not be discernible from a mere reading of the judgments. So that was the intention that I will be able to analyze and give a slightly different perspective than just surveying the case laws for you. Now, as you can see, these are all in the direct tax, which we are going to be discussing. I'm going to move forward with the slide. I've prepared a PowerPoint as a visual aid to discuss, but I'm not going to read it out. These are bullet points mostly. Now, the first thing that I'll discuss, and I'll just, I know some of these decisions may have already been discussed in your earlier study groups, but I just wanted to share with you a few of my thoughts because in both these decisions, where a certain different kind of approach was appearing in the courts, I had defended the revenue, one successfully and one unsuccessfully. Section 292B is something that is commonly used by the revenue to defend actions which the courts often hold as jurisdictional defects. Now, in cases where amalgamation takes place and notice is issued on a dead entity, the law has become quite well settled after Spice infotainment that any notice issued to a dead entity will be non-est and will be invalid in the eyes of law, being a jurisdictional defect, cannot be cured under 292B. So when Skylight came up as a case which had identical facts, where a company had ceased to exist and converted into a LLP, and a notice was issued despite the assessing officer having been informed of such a defect. A notice was issued in the name of the erstwhile company. Now, the difficulty I was faced with during the hearing before the Delhi High Court was a barrage of precedents which had settled the law against me. So I did a little bit of research and I found that the one judgment of Justice Khanna, who was the presiding judge in Skylight, had not been cited. The decision was Jagat novel. And in that case, even though the facts were distinguishable, but two principles emanated. And I just want to highlight that for you because that's not a judgment which has been discussed very widely. The first principle that the court had laid down while upholding the revenue's action was that when a notice is issued, is there any confusion in the mind of the assessee as to who is this notice for? This was the first question raised. The second test which was applied was the prejudice test. Has this issuance of notice incorrectly or in the incorrect name led to any prejudice to the assessee? And the court held that technical defects, technical stratagem will not be tolerated or it will be a basis to thwart genuine assessment proceedings. Now, factually, the defect in that case was a very minor defect. Jagat novel exhibitors Private Limited was written as Jagat Novel Exhibitors. That's it. The Private Limited part was missing. So that the court held is a curable defect under 292B. Now, applying that to Skylight, as far as the test is concerned, in a way appealed to the bench because it was the same bench's decision and ironically not taken into account by subsequent benches while considering 292B, which as a matter of judicial discipline is usually considered and taken into account. Now, I cited that. I also showed all the jurisdictional steps that were taken prior to recording of reasons, which finally noted the assessee's name incorrectly. In those jurisdictional steps, interestingly, when the reasons were put up before the range head and the range head thereafter forwarded it to the PCIT for approval, the factum of the assessee having amalgamated was noted and those were put up in the correct name. These factors weighed in with the court. Ultimately, the court upheld the action of the revenue, and this matter traveled all the way to the Supreme Court. And interestingly, it traveled to the same judge who had authored Spice Infotainment, which was Justice Sikri. So Justice Sikri pointed this out, and then we distinguished it. So the first day we were on caveat, the learned Solicitor General led us in that matter, and we managed to successfully distinguish it. And the dismissal order is an interesting one, which has been taken note in Maruti Suzuki by Supreme Court. It says, in the peculiar facts of this case, the present SLP is dismissed. Now, as you are aware, the doctrine of merger will not apply in a dismissal simpliciter. But there are two views as to when a dismissal of a SLP is done simpliciter without granting leave, but with certain observations. Would the doctrine of merger apply? And would it then amount to being law declared by the Supreme Court? Which means that the High Court judgment is now having been dismissed by the Supreme Court with some observations, having merged with that order, has become the law of the land. So this was an argument that was taken by me before the bench led by Justice Chandrachud in Maruti Suzuki, where also I happened to defend the revenue. Now, I just want to share one interesting snippet about Maruti Suzuki. I won't go into the details. The interesting part is a prior year of Maruti Suzuki had already been dismissed simpliciter a couple of weeks before this matter came before the court. The first thing that I did before the court when this matter came up was point out to the court that, look, an earlier year has been dismissed by a coordinate bench. However, I want to point out that there is prima facie conflict of views, not only of the jurisdictional court, but also of the Supreme Court. And I relied on certain old decisions. There is a federal court decision of Chatura, which has been followed in subsequent decision of Jai Prakash Singh, where courts have held the basic principle is that a notice is not a foundation of jurisdiction. The foundation of jurisdiction to tax assessees comes from charging provisions. A notice is only an initiation of such proceedings. So if there is irregularity in a notice, it is bound to be challenged and then corrected in judicial proceedings. Thereby meaning that if a notice has been issued in a wrong name, you please permit us to go back and reassess after giving them opportunity if adequate opportunity is not granted. The Supreme Court, interestingly, Justice Chandrachud was very kind enough to issue notice. Mr. Vora appeared on caveat on the other side. He tried to argue that, look, the decision is covered by a dismissal order of Supreme Court. But Justice Chandrachud said, no, we would like to examine it. And then when the matter, he promptly took it up for final hearing after a couple of months. And he heard the matter for an entire day. And ultimately, in his judgment, it's a long, detailed judgment, and it's a well-principled judgment. He took one of the reasons for not interfering was judicial certainty, that there must be certainty and assessees in the country must have some sense of certainty once a law has been pronounced by court. And repeatedly relooking it may not be in the interest of that judicial certainty. So that was one reason which weighed against the revenue in that matter. He also noted, and this is something which tax practitioners and advisors may consider noting, he noted that all these decisions which has been cited by the assessee are decisions where the assessing officer has been informed by the assessee of the amalgamation of the entity prior to issuance of the jurisdictional notice, which is to say, wherever the notice is a 147 or wherever it's a scrutiny proceeding and a notice is a 143.2, prior to that itself, the assessees were diligent enough to inform them that the company is no more, it's a dead entity, it is amalgamated, and this is the amalgamating entity. Having done so, despite that, when notice was issued in the wrong name, Justice Chandrachud was held that this will not be a curable defect under 292B, and this is the jurisdictional error. Therefore, I just want to point out that the moment one of your clients undergoes such a change, the safest thing to do would be to just inform the assessing officer so that later, as far as the legality of your actions are concerned, it's not raised. Just on Friday, one judgment was reserved in the case of a dead assessee where an individual had died, but the LRs, the legal representatives of those individuals, had not informed the assessing officer of the death. I argued for the revenue, and one of the arguments I took was that there are 45 crore active PANs in the country and large number of individual assessees. It is impossible, in the absence of any provision in the Income Tax Act, to on where there is an obligation on the revenue to find out whether an assessee is dead or alive and then issue a notice. It would be impossible for the revenue to do this exercise prior to issuance of notice. And therefore, since there is no authority of under the law which obliges the revenue to do this exercise, the obligation is on the assessee's LR to inform the revenue whenever an assessee ceases to exist or expires. So this argument was taken, and the matter is sub judice. The judgment has been reserved. But I'm just saying that 292B may not yet be a complete dead letter in terms of these kind of controversies, and that we may see it being applied in a variety of different situations. Moving forward, there is, if you can see the second bullet point, there's one recent decision of Lakshman Das Khandelwal. You may have discussed it in your study groups already. This was a case where no notice under 143.2 was issued, but the assessee nevertheless participated in the proceedings. 292BB was cited by the revenue to say that the entire procedure has been saved, even though there is an absence of notice. The Supreme Court came down and said that, I'm sorry, in the absence of a complete absence of a notice, even 292BB cannot save the proceedings, because that is a sine qua non, and Hotel Blue Moon, etc. was cited. So what the Supreme Court says that in case of defect in service of notice, 292BB can certainly be invoked, but where there is a complete absence, I'm sorry, this can't be invoked. Moving forward, also I have earlier said that there will be a diverse range of topics, because these are decisions which are by and large evolving, and there are interesting issues coming up. So now one of the things that we have seen evolving is nature of subsidy, whether it is capital or revenue. And I happen to have defended on this issue as well, both before High Court and Supreme Court. And I'll just give a brief flavor. You are aware in Sahani Steel and Pressworks Limited, which was a 97 decision, the Supreme Court even held that the nature of the subsidy in that case, even though it was for promoting industrial development, etc., was in the nature of of revenue receipt. The reason for this was that the court found that the assessee was free to apply the subsidy in the manner it chose, and that it was not bound to apply it only towards capital expenditure. And therefore, it was found that it will be revenue in nature. So I will just read out the basic test which has been laid down here, and I've underlined it. It is not the source from which the amount is paid to the assessee which is determinative of the question whether the subsidy payments are of revenue or capital in nature. And then, here, if any subsidy is given, the character of subsidy in the hands of the recipient will have to be determined by having regard to the purpose for which the subsidy is given. If it is given by way of assistance to the assessee in carrying on of his trade or business, it has to be treated as a trading receipt. So it will be in the nature of an operational subsidy. So the court found it to be revenue in nature. Interestingly, when Sahani Steel came up again in the case of Ponni Sugars, the court held that this will be capital in nature in light of one very important condition which many judgments often overlook. The condition was that pursuant to the scheme, the assessee will only be able to expend this subsidy towards repayment of term loans which was taken for the purpose of capital asset. There is one small para of discussion. While distinguishing Sahani Steel, the Supreme Court, again a coordinate bench of 2 judges, said that the benefit which had to be utilized was only for repayment of term loans. The assessee was not given a free hand in how it could use its subsidy. In light of this, the purpose test upheld in Sahani Steel was again applied. Now, interestingly, this thereafter came up in a decision which was before Justice Nariman. There the issue was subsidy granted for development of multiplex cinemas. Now, I had also appeared in the Supreme Court, but I was being led by the learned ASG in that case, Mr. Narasimhan. And one of the arguments that was taken was that you have to see the immediate purpose, the larger purpose, and not the immediate purpose. And the court rejected it, relying upon Ponni Sugars, Balaji Alloys, etc., saying that, look, the purpose test has to be applied. There is no concept of immediate object or larger object, and that the object of the scheme is construction of multiplex cinemas. It is capital in a capital intensive entertainment center. Therefore, this is nothing but capital in nature. Now, I just want to give you a flavor of a decision which I had argued before the Delhi High Court and Justice Ravindra Bhatt's judgment. It's an erudite judgment, and it's Bhushan Steel and Strips Limited, which has been challenged before the Supreme Court, and I believe there may be a stay. In that case, the Ponni Sugar and Sahani Steel has been applied, and the court noted this fine distinction that there is nothing in the scheme which binds the assessee in the manner in which such subsidy will be enjoyed by him or expended by him. In the absence of such a provision in the scheme, the court finally held that this has to be revenue in nature because it is nothing but an operational subsidy. It will help the assessee in day-to-day trading, in day-to-day function, and it has to be a trading receipt. Now, I will straight away go to the decision of SR Shipping Limited, which is a recent judgment of the Bombay High Court. In fact, it came on the 5th of March 2020. The question that was raised there was whether the waiver of loan by government of Karnataka attracted the provision of section 28 subsection 4, but being in the nature of benefit or perquisite other than cash. You will note that section 28.4 has had a long history, and the courts have often held that there can't be a cash component to a benefit or perquisite which falls under the definition of 28.4. On the facts of this case, the CIT appeal had held in favor of the assessee, saying that the waiver of loan is a cash item. However, this was reversed by the ITAT, finding the AO's action to be correct in law. The High Court in its discussion relied upon the judgment of the same High Court confirmed by the Supreme Court in Mahindra and Mahindra, which had laid down this principle that for section 28 subsection 4 clause 4 to apply, the benefit or perquisite must arise from business. The benefit must not arise in cash. And the revenue had relied on Sahani Steel, saying that this is waiver of loan is nothing but a subsidy from the government. And this subsidy is in the nature of a trading subsidy. It helps the assessee run its business more efficiently, and therefore it has to be treated as a trading receipt. The High Court discussed the law in Mahindra and Mahindra. The facts of Mahindra, if I can just very briefly elaborate. In Mahindra and Mahindra, there was a loan taken by one Kaiser Jeep company. And that once that Kaiser Jeep was taken over by US Automotive, the decision taken by the new company was to waive this loan in favor of Mahindra. The question arose whether this waiver of loan will amount to income by falling under 28 subclause 4. There, and if I may quote what the Bombay High Court held, which was upheld by Supreme Court, benefit must be in some other form rather than in the shape of money. So the Supreme Court said that the first condition of section 28(4) itself is not met, that the benefit or perquisite other than in the shape of money is not satisfied. And that is the plain language of the text of the provision. Therefore, applying this law, the Bombay High Court in SR Shipping finally rejected the argument of the revenue that this is in the nature of subsidy and refused to uphold the addition under 28(4). One more thing which is interesting is that the concept of loan was discussed in contradistinction to the concept of subsidy. Loan, the High Court said, is a borrowing which has to be returned, whereas subsidy is a grant which has to be utilized provided there are any conditions in the subsidy or the grant which is being given. So keeping this conceptual difference in mind, Sahani Steel was, in my view, rightly distinguished. Now, if I am engaged to appear in this in Supreme Court, I may have to argue something else. So please don't use this lecture as an estoppel to my esteemed colleagues listening to this. Moving forward. Vodafone is a recent judgment which was pronounced during the lockdown, I think in the last week of April 2020. And this is, in fact, the first decision of the Supreme Court on section 143(1)(d) and 241(A). The issue of withholding of refund spread over multiple years. Some years were prior to assessment year 17-18, and there was 1 year for 17-18. And as you are aware, 241(A) kicks in only from 17-18 onwards, where the regime has now changed and requires all returns to be processed first, where a refund amount is generated and determined, and thereafter the assessing officer, for his reasons to believe recorded in writing, on the belief that issuance of refund will be adverse to the interest of the revenue, with the prior approval of the PCIT, now proceeds to withhold refund. So this was the issue which was in question before the Supreme Court. Before the Delhi High Court as well, I had appeared, Mr. Salve had appeared for the assessee Vodafone, and he had taken a very novel argument, and he had restricted his argument to that. The argument was this, that under 143(1)(d), if you have to exercise the power to withhold refund, you must do so within the time limit prescribed for processing a return under 143(1) of the Act. That is 1 year from the date of filing of the return. This argument was rejected by the Delhi High Court. The Delhi High Court noted copiously my arguments also, and finally came to the conclusion that the non-obstante clause in 143(1)(d) means that everything else contained in the rest of the provision will have to be necessarily excluded, including limitation. Reading the limitation into the non-obstante clause, I had argued, would amount to supplying casus omissus or saying something in the law which does not exist. This view was upheld and all the 4 years withholding was granted. The Supreme Court now has gone a step forward and accepted the view, the argument of the revenue, that even the moment a 143(2) notice is issued, the assessee will not have a right to seek refund. If it is granted to him, it's a different matter. The AO in his discretion may grant it to him. But he will, his return having become suspect, having been picked up for scrutiny, will not be entitled to a refund unless it is granted by the assessing officer. Similarly, 241 capital A was also found to be correctly exercised, and the court, as far as the total amount that was withheld, you can see in the screen, first line, it was around 4759 crores. Both the withholding orders were upheld by the Supreme Court. What was allowed to be released, and somehow this is the only thing that the media also picked up, was that 745 crores of refund was allowed to be released by Vodafone by the revenue. Interestingly, this was an amount which had already become due to the assessee during the pendency of the Supreme Court proceedings pursuant to a scrutiny assessment. Even this, the Supreme Court held that subject to your right to adjustment under 245, you shall issue it within 4 weeks. So these proceedings culminated in this way. Now, even under lockdown, as you are aware, large number of assessees are approaching the jurisdictional high courts under 226, primarily on the issue of refunds, because in some cases, revenue does exercise its discretion correctly. In some other cases, it becomes quite a mechanical approach, and reasons for scrutiny alone become reasons for withholding, which even the recent decision of the Delhi High Court in Maple Industries has strongly observed against. Justice Narula's very erudite judgment says that you cannot have a ritualistic approach for withholding. It must be a reasoned approach, and merely reiterating the reasons for picking up a matter for scrutiny can't be parroted by the assessing officer. I think that's a good approach, because when you are withholding refund, you can't withhold it in a mechanical manner. Refund is a right which an assessee has. It may even be, if you apply Mafat Lal, etc., it may even be a right which is over and above the statute, and it can be elevated to a right under 300A of the Constitution. Moving forward, ConnectWell is a recent decision at the request of Sharma ji. I have taken this up. This is a decision where priority of claims has been gone into by the court. The age-old principle that a secured creditor has a better right, even better than crown debts, has been applied here. Here the facts are interesting because the court actually went by which was the claim which was prior in time. Therefore, even though there was a TRO's notice which was issued, nevertheless, the court recorded that the properties in dispute were mortgaged to the bank in 2000. The DRT's order of recovery against the company was of 2002. The recovery certificate was also issued immediately. It was pursuant to that which an order was passed, and this order was prior in date to the notice issued by the tax recovery officer. So the question before the High Court was that a bona fide purchaser who has purchased the property in auction sale as per the order of DRT, whether he was entitled to have the property transferred in his name in spite of the attachment of the said property by the department. It was in these facts that the Supreme Court held that the sale was conducted even though after the issuance of notice and the attachment order by the TRO. Nevertheless, the charge over the property was created much prior to the notice issued by the tax recovery officer. So, in fact, even in the IBC context, you would have noticed when a claim is filed becomes a relevant factor, whether it, even when recoveries are initiated. Now I am appearing for ED in certain matters where conflict of PMLA proceedings and IBC are there, and this raises very interesting questions of how do you resolve these competing claims under different statutory provisions. So I will not dilate on that. Moving forward, Exide Industries is another decision which has recently come into light, where the provision of 43B clause F was subject matter of a constitutional challenge before the Supreme Court. Now, this is a provision where on actual payment, a certain deduction would be available to the assessee in lieu of the liability that is accrued under leave encashment scheme. Now, the court after arguments on both sides, applied common sense and held that wherever an employer is seeking deduction in advance with respect to leave encashment without having actually paid that to the employee, and when the time for payment arises, he may just refuse, but the benefit of the provision has already been taken by him. Therefore, the court found that there is some rationale, it is not arbitrary, and that this creates a tax disincentive in favor of companies or employers who don't make immediate payments to employees. So keeping this pro-employee view in mind, and also the fact that, in taxing statutes, there is a wide latitude given in judicial review, the court upheld the vires of the provision. Ramnath is another decision which came recently. This was a case where the deduction under 80O, which is a very specific provision where certain payments are received from foreign enterprises. Now, the court said that any and every payment received from foreign enterprises will not qualify for deduction for under 80O. It said there is a very categorical species of payment which must have been received for a claim under 80O to be upheld. And if you see, the provision has been extracted. I have just underlined what is the nature of that payment under which an 80O claim can be made. Such a payment has to be any income by way of royalty, commission, fees, or any similar payment received by the assessee. So this any similar payment is clearly the law of nociter soci or ejusdem generis, whichever may have to be applied to see that it must have the color of royalty or commission fees. Keeping this in mind, the court held that the agreement, they analyzed the agreement in question to say that irrespective of whatever certain provisions might have, so there were expressions in the agreement like expert information and advice, analysis, technical guidance, but the court said that we will look at the holistic agreement and take a holistic view after reading the entirety of the agreement. Having done so, the court said this is nothing but a procurement agent. The assessee has been engaged has been engaged as a procurement agent if all the services are essentially connected to and incidental to the main function as a procurement agent. And therefore, the court upheld the High Court's view that the assessee was a procurement agent and did not fall within the scope of services mentioned in 80O necessary for claiming deduction. Ventura Textiles, another...
Sir, if I remember, in this case, I think there is also an issue of the deduction, whether liberal interpretation is to be taken. Is that the same case?
Yes, yes. In fact,
to show something on that, sir.
Yes, I'll thank you for pointing out, Sharmaji.
Yeah.
If you will see the last para of the judgment, I'll just go back to the slide. In Ramnath, the last para, in fact, the argument taken by the assessee was relying on the Constitution Bench decision, which came recently, that in a deduction provision or an exemption provision, the provision has to be construed liberally. But the court said that the court rejected this in the last para, saying that argument will not in any way, even if we construe it liberally, it will not avail to the benefit of the assessee because we are applying the provision as it stands. Liberal construction does not mean that you will deviate from the text of the provision. And according to the text of the provision, the court said it will only be restricted to payments which are in the nature of royalty, commission fee, or any similar payment received by assessee. So procurement agents' work was not found to be within the scope of 80O deduction. Now, while reading this judgment yesterday, a thought came to me. Now, I am defending, in fact, several live matters under DTAA, where we seek to bring within the tax fold services which are of a similar nature. So I may find it now difficult after this judgment by relying upon certain clause to say that these services are or will fall under the meaning of fee for technical services. So this sort of a judgment is always double-edged. In some cases where the assessee stands to gain on this interpretation, there will certainly be cases, far more cases, where the revenue will stand to lose.
They have also discussed about Dilip Kumar's case, I think, in this case.
Yes, Dilip Kumar, that's the Constitution Bench judgment,
yes,
where the court had held that the provisions which grant deductions or exemptions will have to be liberally construed. This was argued by the assessee in its favor, but the court said, irrespective of that principle, we can't hold in your favor. Moving forward, Ventura Textiles is a decision where the earlier principle of Reliance Petro product has been reiterated, that merely because a claim is found not admissible, it would neither amount to furnishing inaccurate particulars nor amount to concealment. There is one more issue which this case discusses and which may be a little controversial because there are conflicting views as well of different high courts, that not striking the correct limb under 271(1)(c) would itself be fatal to the penalty proceedings. The court has said that while the notice mentioned furnishing inaccurate particulars as the head, the assessment order proceeded and mentioned both concealment and furnishing inaccurate particulars, and this is sufficient to vitiate the order of penalty. Now, this view, according to me, may not be entirely correct because there are certain other contrary views of the Supreme Court, but maybe, and there are contrary views of the High Court as well. But this issue has not directly arisen before the Supreme Court. And in a sense, I think the law regarding this will require to be clarified, not only for the benefit of assessees, but also as guidance to what the revenue should do when a penalty notice is issued. Intech Corporation is another decision, which I'm not sure if you have discussed in your study group, but I will quickly run through it. It was also argued by me in the High Court and is one of the few decisions under Section 150. As you are aware, under Section 147, read with 148 and 149, the limitation, the outer limit for reopening an assessment is 6 years at best. 4 years if you can prove that assessee has failed to disclose truly and fully, you will get an extension of 2 more years up to 6 years. But there is no way you can go beyond 6 years unless, of course, it's a foreign asset. Then the law says now reopening can be done up to 16 years. But as far as normal domestic cases are concerned, 6 years is the outer limit, with the exception of Section 150. Now, 150 is interesting because it says that in consequence of or pursuant to a direction of or order of a higher authority or a court or a tribunal. So, in the facts of this case, it's very interesting. There was an 80 IC deduction that was being claimed. The assessee had a favorable order from the CIT appeal in 1 year. When the AO was passing its scrutiny order for the subsequent year, the assessee showed him the CIT appeal order saying, look, you are bound by it. The matter you have challenged before ITAT. When the ITAT passes an order, that would be binding on me. So right now, you please grant me the deduction. AO followed the order of the CIT appeal, granted the deduction, and recorded this fact, which was not disputed. Subsequently, the ITAT reverses the order of the CIT in the earlier year. This ITAT order then is used by the AO to reopen after 6 years for the other year. The assessee comes before the Delhi High Court saying you cannot do it because of the limitation that it must be an observation in the very same year. Only then can you reopen it. The Supreme Court, the Delhi High Court, again, Justice Narula's judgment, after a very detailed analysis of the various judgments of the Supreme Court, including Greenworld Corporation, said that the limitation of the fact that it must be in the same year was the law as it stood prior to the amendment. And Greenworld has clarified that it can not only be for a different year, the observation, it can also be in the case of a different assessee. So in other words, if an income is found to be assessable, my income, by an appellate authority in the hands of my brother, then that order can form the basis of a valid reopening against my brother. The only limitation is this: such an observation must be made by the appellate authority for deciding the subject matter of the appeal before it, which is to say, it should not be an obiter. How I understand this, it must be a ratio and essential for deciding the subject matter of the appeal before that appellate authority. So and this is the law that has been laid down by Supreme Court and also followed by the Delhi High Court in Intech. Finally, applying this law, the court said, look, the assessee had taken the benefit of the order of the CIT appeal and had said that they were to be covered by if the order is reversed in appeal. And now that it has been reversed, it can certainly form a basis for reopening. And there were some various factual findings on 80 IC by the tribunal, which would have an impact on reopening. Now, I had also relied upon several decisions of the Supreme Court, where the Supreme Court had said that observations of one assessment year, which are found subsequent to the completion of the original assessment, can certainly be a basis for reopening. Moving
Om
forward.
Namostu Suryaya Sahasra Kiranaya Riddhi Siddhi Karaya Manovanchita Puraya Puraya Kasta Churaya Churaya Om Shri Suryaya Namaha.
Vipul bhai.
Om Shrim Him Shrim.
Vipul bhai.
Vipul bhai.
Yeah, Joab sir. Yeah, you can continue, sir.
Yes. Bharti Infratel, it's...
You were saying, sir, observation of Supreme Court, you were that time. Yeah.
Yeah, I'll repeat it.
Yeah.
There are two
Rajesh bhai.
limitations to the...
Hello.
Yes.
Hello.
No, it's okay, Vipul bhai. There was some in between. There was some, yeah. No, nothing.
Bolo.
In between there was some noise. Now it's okay. Thank you. No problem. Please continue, Zoib sir.
Yes. There are two limitations to the power under Section 150. The first is that any observation made by the appellate authority, either a tribunal or a court or a Supreme Court, ought to have been made in the course of the earlier proceeding, which is essential to decide the subject matter of the appeal. It can't be any observation which is by the way. So number one, such an observation can be the basis of reopening under 147 read with 150. The second limitation is contained in subsection 2 of section 150. And this is the interesting inbuilt safeguard which I want to bring to your attention, because it has again not really been litigated upon. There is one Gujarat High Court Division Bench and one Calcutta High Court Division Bench. That's all. But it has been noted in this decision of the Delhi High Court in Intech Corporation. And I would urge you to see it, because it's a provision which is not very litigated upon. And if you come across it, it may be of some help to you. I'm sorry, I'll just go back to Intech here. Yes. The safeguard is this. The order which is made the subject matter of appeal. So in this case, it was the CIT appeal order which was made the subject matter of appeal before the tribunal, which then reversed it. And those findings of the tribunal was used by the assessing officer for a different assessment year to reopen. Now, when the CIT appeal order was passed, could the assessing officer have reopened the earlier assessment year? If the answer is yes, only then can the ITAT order subsequently can be the basis of reopening. If the answer is no, then it cannot be reopened. In other words, assuming 6 years had lapsed when the CIT appeal order was passed, reversing the AO's order in the earlier year, in the other year, then the AO could not have legitimately used the ITAT's finding to reopen the case. This is what I have put in the last bullet on the screen. And this is the language of the statute. The assessing officer could have otherwise initiated reassessment proceedings on the date on which the impugned order in such appeal or revision was passed. Moving forward. Bharti Infratel is another decision where explanation 1 of section 147 and the proviso of section 147 have been reconciled. The court has held that the assessing officer has to apply his mind to the material facts, but his failure to draw legal or other factual inferences will not be protected under explanation 1. Explanation 1, as you are aware, is the explanation which had come up for consideration in the Court of Calcutta discount, Supreme Court decision, where the court had said that legal inferences cannot be construed to be primary material facts for the purpose of showing failure to disclose truly and fully. The only responsibility of the assessee is to place primary material facts and not to draw any further legal inferences for the AO. Once he has placed these primary material facts to the AO, it is the AO's duty to do the rest. Failing to do that cannot be compensated by relying on explanation one. This is the decision of Bharti Infratel, which the Delhi High Court has very carefully discussed. The next judgment on your screen, Aditi Infrabill, is a decision where in fact, it shows a writ court's angst and anguish, where a lot of assessees keep filing writ petitions repeatedly, even during the pendency of assessment proceedings, without any real cause of action. The well-settled principles of alternate remedy, the well-settled principles that you cannot really be aggrieved against a show cause notice, and the reluctance of high courts to entertain transit writ petitions has been expressed here. The assessee here came before the court after her reopening was rejected in an earlier proceeding. Challenge to her reopening was rejected in an earlier writ proceeding. She again came asking for the investigation wing report itself on the basis of reopening was done. This was against a letter of the AO where the AO had said, look, I will give it to you before I finalize the assessment. But during my scrutiny proceedings, I want to examine the matter and put questions to you. So I had argued that, and taking cue from criminal law investigation point of view, the manner in which questions are to be put, the timing in which questions are to be put, these are all the subdomain of an investigator, and the courts have been very, very reluctant to interfere with the procedure of investigation or inquiry. There are several decisions of Supreme Court and High Court which say, and they have been cited in this judgment by me, that an AO is not just an adjudicator, but also an investigator. And in his role as an investigator, he is within his rights to put questions on the basis of material before him to verify the veracity of the answers of the assessee. So if there are some sham transactions which he has received information on the basis of investigation wing report, he is entitled to look at that document and put questions to the assessee to verify how far they match or they don't match. And revealing the report at the crucial stage of assessment proceeding would jeopardize assessment. So all of these were taken into account. And if you see the screen, the court held, if such petitions, I'm quoting from the quoted portion, if such petitions are routinely entertained, not only would it lead to opening of floodgates, but also it would be extremely difficult for the assessing officer to complete the assessment proceedings within the period of limitation prescribed under the Act. There is a Gujarat High Court decision. There is also one decision by Justice Ravindra Bhatt called Ecorus. It's a famous decision where a similar plea was taken of not having been given a 2G report, and it was argued by the assessee that this alone vitiated the entire reassessment proceeding. The court had rejected it straight away and said this cannot be the basis of quashing the reassessment proceeding. Moving forward. This is a slightly technical decision where which provision of limitation will apply. I will only flag it for one principle which the court upheld. In a settlement commission proceeding, there are the argument that was taken by Mr. Agarwal, who is a renowned senior advocate, has been arguing even under the 1922 Act. His argument was that under the settlement provisions governing settlement commission, after you have allowed the proceedings to be proceeded with, either under an order under D2C or the prior order, once it has been allowed to be proceeded with, you cannot thereafter simply reject the application in the final order under 245(d)(4). The argument was a final order rejecting the application after finding that the application had been made as a true and full disclosure under 245(c)(1) and allowed to be proceeded with under 245(d)(2)(c). You cannot thereafter say that it is not a true and full disclosure in the final here proceeding under D4. This was rejected, saying and relying upon decisions of the Supreme Court in Ajmera Housing, Delhi High Court's decision in CIT versus Settlement Commission. And it was held that this does not amount to review. It was also held that the Settlement Commission at the final stage has the benefit of various reports that are filed from time to time by the revenue. And therefore, a final view after full appreciation of facts and the law taken by the Settlement Commission at the end can certainly entitle it to reject the application at the D4 stage also. This was further found support in the statutory provisions of section 245 capital HA within bracket small Roman 3A, where the provision itself says and contemplates an order under 245(d)(4) without providing for terms of settlement. And that's when the proceedings abate. So it's not as if the Act does not contemplate a situation where under 245(d)(4) a settlement would not be arrived at. Once this initial hurdle was crossed by me, which provision of limitation was applied, would apply, was then followed naturally and consequentially. And the 1 year period available was given to the revenue as against merely 60 days to initiate the proceedings under 153C. So moving forward.
Sir, though the name of the case is there on the screen, but kindly repeat it for the participants. Sir.
The case is Rohit Kumar Gupta versus Principal.
Yeah, I'm saying all the judgments whenever you are discussing.
Yes, I'll do that.
Please. Yeah.
Now, I must also point out this decision of Rohit Kumar Gupta is now in appeal before the Supreme Court and is sub judice. And I may be appearing in these as well. I've been engaged. So I will, beyond the point, not dilate on a matter which is pending. Principal Commissioner of Income Tax versus Vandana Gupta is an interesting decision of the Delhi High Court. This was a case where, pursuant to a survey conducted during the course of assessment proceedings, the assessee suddenly surrendered additional rupees 2 crores and revised her return to reflect the same. It was argued by the assessee's counsel that the voluntary surrender of rupees 2 crores would not attract penalty under 271(1)(c) for concealment of income and furnishing of inaccurate particulars, because she had done it on her own voluntary volition, and that this will not attract the violation of 271(1)(c) because the revised return, which would be the subject matter of assessment, contained the material particulars. The court interestingly rejected these arguments. The court agreed with my submissions on behalf of the revenue that the revised return was only filed after having been detected in survey. This cannot be even held to be a voluntary return. Even assuming it was voluntary, the law laid down in MAC data by the Supreme Court was applied that the mere offering of the amount during search in the absence of any explanation regarding the source of such income would render the assessee's argument untenable. So the court, on a factual position, found that the assessee was unable to explain the source of such income and that merely offering it during having been detected, would not absolve the assessee from the rigors of penalty. Moving forward.
Sir, MAC data, of course, was also on the facts of its own case, sir. That cannot be generally applied, because in that case, if I remember, the offer was after some 10 months after the survey, etc.
Yes.
Yeah.
Yes, you're right. In fact, Justice Ravindra Bhatt, who is the author of this decision,
yes, sir,
himself has, in another decision, the name of that decision immediately skips me, has held that after a search, if somebody comes forward and files a return under 153A or 153C and offers the entire income which was found pursuant to incriminating material in search, then penalty will not be levied. I can't recall the name of the judgment immediately, but that's a judgment under 153A or C. And pursuant to search, the entire amount was disclosed. So there are different views, you're right, and it must show a bona fide conduct of the assessee for any court to then render a finding in their favor.
You can share it, that judgment, afterwards, sir. I'll request you.
I'll share that judgment. That's a landmark decision of the Delhi High Court and is now binding precedent.
Right.
Brahamdev Gupta is on 263, section 263. I'm sorry, this, I'll come back to it because I think this judgment is can be found later. I'll come back to it. Let us start with BSES Rajdhani, and this is interesting because the scope of section 263 was decided by the Delhi High Court. A short point that was involved was Mr. Vora appeared for the assessee. The short point that was involved was that if the assessing officer has made an addition and that becomes a subject matter of appeal, then 263 cannot be invoked. That is the basic principle that is there as a limitation under the Act as well, section 263. Now the question was, if there is an addition of, let us say, 10 rupees by the AO, and that is the subject matter of appeal, can the CIT in its jurisdictional power, revisionary power under 263, say that this 10 rupee was incorrect, the correct amount should be 100 rupees that was added to the income of the assessee, that should have been added. The court went into the argument, the matter was heard for an entire day, and the court, after seeing some precedents of the Supreme Court, which has been put on the screen before you, Aruba Mills Limited, found that the non-consideration of a larger claim for depreciation and consideration of only a part of it by the assessing officer, who did not go into the issue with respect to the whole amount, was an error that could be corrected under section 263 of the Act. So this is a jurisdictional issue which was decided by the High Court. And as far as the subject matter of show cause notice which was raised, there this decision in Amitabh Bachchan was applied that failure to issue notice in a 263 proceeding will not vitiate the exercise of power as long as the assessee is finally heard and given opportunity.
So what Amitabh Bachchan says is, as long as the assessee was given the notice during the course of the proceedings, then that is a sufficient compliance.
Amitabh Bachchan is again an interesting case, and it has its own history. And I'll just share briefly what the issue was. In Amitabh Bachchan, the issue was that the order under 263 had issues over and above the show cause notice. And on that ground, a point was taken on behalf of Shri Amitabh Bachchan that on the ground of administrative law principles, that the notice should be self-sufficient and you cannot traverse beyond the notice in your final order. And that would amount to violation of natural justice principle. On our side, I was led by Mr. Ranjit Kumar, the Solicitor General. I was assisting him. There were two old precedents which I had found, which I had brought to the attention of the learned solicitor and the court, where the Supreme Court itself had held that there is no legal requirement of even a show cause notice under 263. The court, Justice Gogoi, in fact, was the judge in Amitabh Bachchan, heard the matter and upheld this view that even though there is no requirement of a notice stricto sensu under 263, natural justice will be sufficiently complied if the assessee is given a broad chance of representation and hearing. If you hear the assessee, now to a legally trained mind, this may appear to be a little incongruous, because what will you hear a person on if you don't give him a notice? What will you hear a person on if he doesn't have points on which he can make his representation? So this is something that may be argued by some bright assessee counsel at some point and maybe seek a reconsideration of Amitabh Bachchan. But as on today, the law as it stands, there is no requirement of a notice under 263, so long as the assessee is given a broad chance to be heard during the proceedings in 263. I must also share, without drawing any adverse inferences, that during the week in which Amitabh Bachchan's case was being argued, the matter had spilled over. You know that the hearing days in Supreme Court are Tuesday, Wednesday, Thursday. The matter was argued on a Wednesday and Thursday by Mr. Diwan appearing on behalf of Amitabh Bachchan. And we had just started our turn, and the bench was quite posing quite difficult questions to us. And then the matter spilled over to the next Tuesday. During that weekend on a Saturday, the Panama Papers leak happened with the Cinestar's name in it. And that's one coincidental fact I just wanted to share, which of course does not find mention anywhere else. I'm not suggesting anything. It's just something as a interesting trivia that I thought I'll share with you. There is then this decision, which was a recent decision in Sanjay Sani. For tax practitioners, procedurally, I would request you to go through this decision. It will be of immense use to you. I had appeared on behalf of the revenue and did not succeed. The issue in this case was, without having filed an appeal against a CIT appeal order, could the assessee take the jurisdictional objection under Rule 27? So a 153C order was passed making additions by the AO. The CIT appeal, while confirming the jurisdictional objection of the assessee and rejecting the jurisdictional objection, confirming the jurisdiction of the AO under 153C, had proceeded to delete the additions. Not being aggrieved from this order, the assessee never challenged it. The revenue challenged it on the ground of deletion. The assessee, without having filed even a cross objection or a cross appeal, took the plea that under Rule 27, he has the power to challenge the validity of assessment proceedings. The Delhi High Court, after almost 2 or 3 days of hearing, came to the conclusion that this Rule 27 permitted the assessee even to take the grounds which have not been raised, so long as it pertained to the additions. If it is so integrally and intrinsically related to the addition, then this ground can certainly be taken. And for this, they relied on the text of Rule 27 which has been put up on your screen. The respondent, though he may have not appealed, may support the order appealed against on any of the grounds decided against him. So this decision of Sanjay Sahni versus PCIT may be useful for very many tax practitioners because it considers an earlier judgment of the Delhi High Court, and according to me takes a diametrically opposite view. There was an earlier judgment which had held that this is not permissible under Rule 27. So you may see this judgment because in your regular practice before ITAT, this may be of use. Sanvi Info Group is an interesting case of transfer pricing, where even though there is now a decision of the Delhi High Court called Chris Capital, which says that merely because a company has a huge turnover will not be a reason to exclude that company from the list of comparables, provided the other factors contained in Rule 10B of the transfer pricing rules are found. That is, your FAR analysis is otherwise fulfilled, functions performed, assets deployed, and risks assumed. However, Sanvi is a case which says that if it is a giant corporation like Infosys, then it will be a good enough ground for the assessee to seek its exclusion from the comparability analysis. For a giant corporation, you may note that there are various factors like economies of scale, brand value, all of this, which have to be considered as distinguishing factors which permits exclusion of such company. And the court also relied upon Agnity India Technologies Private Limited, which was rendered prior to Chris Capital. And on this ground, Infosys was deleted. This Jindal Metal and Company Limited is another judgment where a revision petition under 264 came up, where a direct challenge to reassessment proceedings was raised in a 264 petition before the PCIT. When that was rejected, the assessee approached the Delhi High Court. The High Court held that not having cared to file an appeal against the order passed in reassessment and having preferred a revision petition after expiry of the period of limitation, the commissioner was justified on the facts of that case in dismissing the said petition. So a thumb rule is that if a lot of times, in some occasions, I find assessee counsels arguing that both 264 and 246A are available to me, and therefore I may choose to prefer either. It is far more advisable to prefer an appeal under 246A rather than take the risk of going under revision under 264. The reason is this. For this, you have to appreciate the difference of jurisdiction, which ultimately the High Court will exercise against such an order. When you file a 246A, you will have the appellate remedy before a tribunal and a 260A before the High Court. Against a 264, which is a non-appealable order, you will have to come in a writ jurisdiction before the High Court. And as you are aware, in a writ, disputed questions of facts are not gone into. The scope of writ remedy is limited. The court will only, in the sense, examine the order under 264 to see whether procedural fairness has been followed and not go into factual minutiae. So therefore, it is much more advisable to always adopt the appellate remedy. NDTV is a judgment which has already been discussed. I'm told by the earlier speakers in the study circle, but having been part of the proceedings, having also partly argued the matter, I was led by the learned Solicitor General in this matter, but he was kind enough to also permit me to address the court. And certain principles which emanate, and NDTV is a bit peculiar because this is the first decision which I have come across in my career where the court has upheld the reasons to believe, saying that the AO was right in his reasons to believe that there was undisclosed income on the basis of the subsequent orders of subsequent assessment years passed by DRP. However, it proceeded to hold that the AO could not satisfy that there was failure on the part of the assessee to disclose truly and fully, and therefore it set aside the notice. Nevertheless, interestingly, preserving the liberty in favor of the revenue to reopen under the second proviso if it is otherwise permissible in law. The second proviso to section 147, as you are aware, relates to financial interest in a foreign asset, and that is a liberty that has been preserved now in favor of the revenue. We are yet to see what happens of that. Moving forward, Jagannath Gupta Family Trust is another case which I had argued. Unfortunately, the court recorded my name incorrectly. And this is a case, interesting case, which came up before Justice Bhanumati, where one of the reasons for cancellation of a registration of trust was a bogus donation that they had taken, and it was found to be in the nature of an accommodation entry. The only argument that was raised by the assessee was that one bogus donation cannot establish the activities of the trust as non-genuine. The Supreme Court reversed the finding of the High Court, saying that the plain language of 12AA3 of the Act was very clear and that serious allegations were made against the trust, and that it is after that consideration of these issues, after proper opportunity was granted by the revenue, that the trust was, the registration was cancelled. And therefore the High Court's view was reversed, because the High Court had held that one bogus donation will not taint the entire activities of the trust, which was found to be unacceptable by the Supreme Court. The next decision, I'm not sure if you have seen it. It's a recent decision by Justice Lalit, where, I'm sorry, this is a decision by Justice M.R. Shah, if I recall correctly. This is the decision where and this is something which happens quite frequently. It's called PCIT versus I-Ven Interactive, 2019, 418 ITR 662. The issue that often arises is that people are quite mobile. They change their addresses frequently. They only mention the address in their return of income and do not care to correct their PAN address. Now, scrutiny notices, etc., were sent to the address in the PAN database. The assessee said, look, I had changed my address long back and I have been filing my returns with the changed address. Therefore, the fact that these notices were issued to my old address and I have not been given a proper opportunity of being heard was rejected by Supreme Court, holding that the scrutiny notice issued to the assessee at the address available as per the PAN database was justified, as the change in address had never been intimated formally to the assessing officer. Mere mentioning of the new address in the return of income without specifically intimating the assessing officer with respect to the change of address and without giving the PAN database change is not enough and sufficient. The change of address in the PAN database of the assessing officer is the must, which is the duty, and this you may mark, it is the duty of the assessee to intimate about the same to the AO. Therefore, this is something that may be taken into account, And in fact, I may also be one person who may have to get this done, because very many years ago, when I got my PAN, I had my native place's address. I have been filing returns for Delhi for the last several years, and I have not even cared to yet change it. I think these judgments are often guidance to a lot of assessees and uh, tax practitioners as to what would be the course correction required on both sides. PDR solutions will be an interesting and important judgment for very many tax practitioners practicing on the transfer pricing side. This is something that has been seen very often, and it has become a criticism of the DRP regime, that the dispute resolution panel, which was started with a lot of hope, has now become, the allegation is that it has now become a rubber stamp of the transfer pricing officer's order, that independent application of mind is not done, and that the Collegium of Commissioners simply approved the order of the transfer pricing officer. One such case came before the Delhi High Court in writ proceeding. The argument that was taken on behalf of the assessee was that the DRP had not considered the main objection that was raised with regard to chargeability, and that the issue was covered by a jurisdictional high court's decision. The court, I, on the other hand, had taken the argument that the DRP's order per se does not give rise to any demand immediately, and that it only translates into a direction to the assessing officer to thereafter follow it and pass an assessment order, which ultimately leads to a demand, and that the assessee will be given an opportunity even during assessment proceedings. The court rejected it. And the second argument I had taken was an alternate remedy, that the court should allow proceedings to proceed as laid down in the statutory proceedings. The court rejected it, saying that there is a fundamental error relating to the jurisdiction, and that this is so glaring and noticeable that we will not relegate the assessee back to the appellate route only to be sent back to the DRP. When the error is so glaring, it is within our right to remand it back. The limitation of alternate remedy is a self-imposed limitation, and that each case will turn on its own facts at the threshold. And therefore, the court remanded the matter back to the DRP, and while at the same time acknowledging that this should not be a shortcut or a floodgate opened up for writs to be filed against DRP orders. Commissioner of Income Tax versus ITC Limited may have been discussed again, and this is a case where lounges were being operated by the company concerned in the Indira Gandhi International Airport, and actual use of the space was the subject matter of appeal, whether it would be amenable to TDS under 194I. 194I, as you are aware, is TDS on rent. However, it is interesting to note, please see the second bullet. Clause 2 of the license agreement, the payment was divided into royalty and fees for space. So one of the arguments taken by the assessee was this is not rent, and therefore they should not be obliged to deduct TDS. The court said, irrespective of the nomenclature that is used in the agreement, what we will look at is the real character of the payment and the nature of the agreement. Ultimately, without the use of space, there is no question of any royalty. The court also looked at the expansive definition of the word rent, which I have extracted in the third bullet. Any rent by whatever name called, and this is what weighed on the mind of the court, that any payment by whatever name called under any lease, sublease, tenancy, or any other agreement or arrangement for the use of either separately or together any building. So the court said, irrespective of the nomenclature, since even royalty cannot coexist outside of or without the use of space, finally it was found to be amenable to TDS under 194I. The court relied upon the ratio of Japan Airlines, even though Japan Airlines was a case where it went against the revenue, but that was on a very different set of facts, where the fact was that an aeroplane landing on the surface and the payments made by that airline to the airport authority, whether that would be in the nature of rent or not. There, the court had examined international conventions, etc., and agreements, IATA agreements, to come to the conclusion that that cannot be treated as rent in any manner whatsoever. Vinod Kumar Gupta is a decision which is very interesting and factual. It is pursuant to a search proceeding. This is a decision which has been affirmed by the Supreme Court by dismissing the SLP. There were two brothers in whom search was done. However, a 153A notice was issued. Interestingly, both the brothers were in the same business. They lived in the same building. And the books of accounts pertain to the same business. However, there was no separate authorization in the name of Vinod Kumar Gupta. The authorization was in the name of SK Gupta. The argument that was taken was, during search of SK Gupta, you found material against Vinod Gupta. Therefore, the correct provision that should have been taken was 153C and not 153A. This was rejected by the Delhi High Court, keeping in view the peculiar facts that even though the authorization was in the name of one brother, because of these peculiar facts, it was sufficient to issue a 153A in the name of the other brother as well, an assassin who was in the same premises, in the same business, and had the same books of accounts. So this was subsequently affirmed by the Supreme Court. This is the decision which I had skipped earlier on 263, Braham Dev Gupta. This is a judgment where I had argued that the AO's order was hopelessly inadequate. It was a one-page order dealing with nothing at all. The PCIT had found that the AO had not made proper inquiry. It had failed to verify the genuineness of unsecured loans. Admittedly, only 37 out of the 114 debtors had responded. AO had not doubted the genuineness of the purchases, etc. The High Court, on a very narrow ground, quashed the tribunal's order. The tribunal had on its own gone ahead and done an entire fact-finding exercise and proceeded on a presumption as if it is against in a regular appeal with regard to an addition, correctness of an addition, whereas the 263 order had only set aside the proceedings to the AO for fresh adjudication. The High Court, relying upon Toyota Motor Corporation, a decision of the Supreme Court, 306 ITR 52, held that the tribunal cannot substitute its own reasonings to justify the order passed by the AO when the AO himself did not give any reason in the order passed by him. And this was found to be a defect in the ITAT's order, where he was supplying reasons in respect of the AO's order. BSCS I have already discussed. I'm going to skip this. NDTV as well has been discussed. I will quickly move forward. This I know these judgments have been discussed, but I will just give you one snippet of the interplay between these two decisions. Cognizant and Genpact. Now, as you are aware, both these cases arose out of the respective assessee's liability to deduct certain tax while making foreign remittances, which were in the nature of dividend as understood under 115O or 115QA. Interestingly, the argument taken by Mr. Ganesh in the case of Genpact, both Mr. Rohatgi and Mr. Ganesh had appeared in the Supreme Court for the SSC. The argument taken by them was that this sort of an order cannot be part of the assessment proceedings under 143.3. Under 143.3, what is being assessed is the total income, and the plain language of 115QA is that this liability is in addition to the total income. This was the argument taken by them. I, on the other hand, appeared for the revenue, and I had argued that the power of the assessing officer under 143.3 is not only with respect to total income, but also with respect to any tax liability as seen from the plain language of 143.3. I had also argued that whatever is contained in your return of income is a subject matter so long as it is part of the Income Tax Act. And short of a challenge to the vires of the provision, without that challenge, you cannot today say that this provision cannot be in the Income Tax Act. So, keeping the totality of the circumstances in mind, the court, Delhi High Court first and then the Supreme Court, in Genpact upheld this argument of the revenue that this can be part of the assessment order. The other issue was that whether this will then be appealable. The court then relegated the SSC back to 246A, saying that you can deny your entire liability. However, interestingly, if you distinguish this with the case in Cognizant, which arose from the LTU division in Madras, Cognizant is a case where the order under 115O, which is chapter 12, was also passed on account of failure of the part of the assessee to deduct TDS on dividend payments made to foreign subsidiaries in Mauritius and US. This interesting feature is this order was not passed as part of the scrutiny assessment proceedings, and it was passed as a standalone order. The court, during hearing, put to me that they've not been heard. What do you say on that? To that, I had spoken to my PCIT and I said that we may consider hearing them provided you protect our interest, because there were around 3,000 odd crores frozen in bank accounts which were attached in favor of the revenue. The court readily agreed, and the court remanded back the matter, protecting the revenue's interest. However, what is interesting to note is, having remanded the matter, the court also held that this will be appealable by the assessee. Therefore, two distinct approaches, qua similar provision, similar liability, has now been upheld by the Supreme Court. One is that it can be part of an order during scrutiny proceedings under 143.3. The other is that it can also be a standalone order. And this, in my view, may appear to be contradictory, but there is no provision in the Act which lays down or inhibits the power of the revenue to pass it only as one or the other. Therefore, it can be passed either as a standalone order or as an order under 143.3 is the position which exists today. I, for one, would obviously like to see more certainty in this regard. And even if it is not provided for in the Act, I feel that the CBDT should provide for it in some sort of its guidelines to the field formations. With that, I thank you, and I would like to end the analysis and the discussion. If there are any questions, please feel free.
Yeah, there are questions, sir. Thank you so much. Now I will request Mr. Ashok and Dilip Bhai to just take a few questions.
Yeah. Sir, I'll read out the questions with their names. There's one Neha Shah. Sir, can you show how show some light on Maruti 43B versus Modi Pawn PLA payment under section 43B? Hello.
Yes, please. Yes,
Yeah.
do you want to take the questions one by one?
Yeah.
Yes, sir. Yes, sir.
Yes.
That will be better.
Yeah. Can you repeat the question one more?
Yeah. Sir, can you show some light on Maruti 43B versus Modi Pawn PLA payment under section 43B?
Yeah. So I have not, I mean, it's been a while since I've read these, so I may not be able to off the cuff point out. But 43B, as I discussed in the other decision also, the Supreme Court has always looked at any kind of virus challenge with a certain amount of circumspection. The provisions of 43B have been very vexed on the issue as to the difference between whether it has already become liable to be paid or accrued. The question of actual payment has also been a subject matter of dispute. Now, this is in a sense a legislative fiction where certain payments, even though the assessee is following a mercantile system of accounting, has to follow this provision where it can claim certain deductions only on actual payment. Therefore, these provisions will have to then be claimed only in the manner laid down in the Act. And there are different kinds of policy considerations which weigh with the Parliament as well as the Income Tax Department when they insert certain provisions. Like you saw, the leave encashment amount has to be claimed only upon payment. What this does is, at a policy level, it has a deterrent effect on companies from not making the payments if they want to claim their entitlement. So,
yeah.
Okay, you may proceed, Ashok.
Yeah.
Second,
Sir, second, Ankita Arora is on the same point where she says that if the lien encashment has got accrued in a relevant previous year, however, it is not due for payment until the employee leaves the company, would provision of 43BF would still apply?
yes, I think it's now very clear. The legislative mandate is only on actual payment can the company claim the deduction. So your internal company policies will have to get arranged in order to avail the benefits under the Act rather than the other way around.
Yeah, sir, then Deepak Joshi says that how do we reconcile the Ventura decision with the well-settled decision of SSA Emerald Karnataka High Court approved by Supreme Court and Manunath Karnataka High Court? Is the stand a valid stand? Shouldn't penalty notice be seen on its own dehorse the assessment order?
You are right in a sense. If you look at it very technically, penalty notices, any notice must put out the charge very clearly. That I think is a very well settled principle of even administrative law. However, if you will see certain judgments of Supreme Court, where the Supreme Court itself has said there is no particular manner in which a penalty notice should be drafted, or there is no particular manner in which the satisfaction of the AO should be recorded while initiating penalty proceedings. If that is seen in light with certain other observations which may not have been deciding this very issue, there could be said that two views are possible. So, in a sense, on a strict principle of administrative law, you're right that the notice must clearly say so. But another issue that some high courts have held is that is there such a vast difference between furnishing inaccurate particular and concealment as legal concepts? And which is something that you may have to consider. This is not as if, an a charge sheet is issued for theft and you are ultimately convicted for murder. This is not such a situation. This is a situation where the two instances may be correlated and even overlapping. In many High Court and the Supreme Court decisions also confirming penalty, I have noticed judges using both expressions interchangeably, or at least saying that furnishing inaccurate particulars has led to concealment of income. So it is a vexed issue, and I would like to see some certainty from the Supreme Court.
Sir, Mr.
Paras bhai, you like to add something on this? Paras bhai, Saula?
Somebody, Mahendra bhai, you are saying something? Hello, somebody wanted to speak? Hello.
No, sir. Paras bhai is online. Paras bhai?
No, somebody wanted to speak. Hello. Sir, only
We go to the
argument,
next question.
Yes, sir, only the argument is I should know what is the specific charge. Now, recently, Bombay High Court has taken the view if that is mentioned in the assessment order, that is also sufficient. What you say on that?
That's right. That's correct. That's correct. You're right. In fact, that is the view that I think even Supreme Court had hinted at earlier, that even if the assessment order where you record your satisfaction to initiate penalty indicates a charge, it will be sufficient. But please consider a situation where assessment order may say X, notice says Y, ultimately penalty order says X plus Y. What happens to such proceeding? And it's not so unheard of that this happens. I've seen it routinely in penalty proceedings, this sort of a thing happening. In an ideal world, I agree with you, you should know the charge. But conceptually, what I feel is these two things may not be so unrelated that these are completely unrelated charges. And I haven't seen enough dilation in judicial authorities on this issue that conceptually these are two such contradictory or different concepts that it requires a specific charge to be made out. But anyway, it's you're right. I mean, there are of course decisions. Some decisions are there, and ultimately some guidance is required. Maybe revenue may not have even challenged most of these decisions, and they have therefore now, having held the field, stood the test of time.
Yeah, sir. Mr. Vipul Jain asked the question whether the taxability of subsidy amended in section 224(18) in Finance Act 2015 can be challenged constitutionally.
Yes, you can of course challenge it, but like I said, some of the old decisions of Justice Holmes in the context of tax law is that the revenue and the parliament, at least the parliament has such a power to make a donkey an ass and an ass a donkey. So to all these fictions, to what extent can be challenged? How is it arbitrary? The onus will be on the assessee to prove. Now you have another category called manifest arbitrariness under Article 14 to prove if any of these fundamental rights are violated. Because please remember, for any statutory provision to be struck down successfully, there are only two grounds of challenge. One is legislative competence, the other is violation of Part 3 or any other provisions of the Constitution. Short of that, the challenge will really be meaningless.
Yeah. Sir, Vipul Jain again asks, observation of Delhi High Court on ICDS is still valid despite of amendment made in Finance Act 2017 on ICDS, as in various sections reference is made to ICDS and the same are already being struck by High Court. How do you deal with this?
Yes, it is. You're right. The findings of the High Court are still valid. They're binding. But I must say that the concept of validation acts have not been unknown to Parliament in India. there have been very many amendments which cure the defect that has been pointed out by a high court, and therefore it is yet to be seen how this pans out, and let's see in times to come what kind of interpretations come up on the issue.
Yeah,
For your information, sir, for your information, ICDS was challenged by our organization only, Chamber of Tax Consultants.
Yes, I know that. I know that.
Right, right.
Know that.
Yeah. Yeah, sure.
Yeah, Sarat Sheth asks, is it necessary for assessing officer to give documents and statements on which he is relying to the assessee before issue of final show cause notice or before passing assessment order? If he passes order without furnishing the same to the assessee, can the assessment order be quashed on that ground?
You are right on the point that basic principle of natural justice requires that prior to finalizing an assessment order, the assessee must be confronted with all the materials that are being used against him. That principle has been well settled. You will find very many judgments on that. In fact, even Justice Muralidhar, while he was in the Delhi High Court, has passed some judgments on this issue. Therefore, that will be a good ground which will render the assessment order vulnerable to attack. However, that has to be done in the course of appellate proceeding. And I have noticed in my experience, whenever assessees take this ground, the CIT appeal, having co-terminus powers with that of the AO, has often corrected this error by giving the assessee an opportunity, by calling for remand report from AO and thrashing out the whole thing. And that often has been considered to be sufficient compliance of natural justice.
Sir, Vipul Jain has asked a question whether additional claim can be filed in return under section 139(1) read with 153A for abated and non-abated assessments.
If there is a fresh notice under 153A, then I don't see any bar in filing an additional claim because it's a fresh return that is being filed. So I don't see any bar unless there is any judgment that you can bring to my attention.
Yeah. If assessee can explain source of income and declare same after survey, or survey, can he escape from penalty under 271(1)(c)?
Yes, certainly. Certainly. And provided he has offered the income. I hope what you're saying is if assessee offers the income after search and survey, explains the source of the income, and then makes a plea that the penalty should not be levied.
Okay. Any contrary judgment to Vandana Gupta's judgment?
There is one. I'll certainly give it to Sharmaji. The judgment immediately doesn't come to my mind, but it was in the context of 153A, 153C, where the court had held that a return filed pursuant to a search assessment.
Yeah, someone has replied it is Neeraj Jindal.
That's the one.
79taxman.com 96.
That's the one.
Yeah. Does voluntary disclosure of income during assessment proceedings attract penalty under section 271(1)(c)? Does the difference of income between original and revised income attract penalty under section 271(1)(c)?
So a lot of it depends on the circumstances and the facts of each case. Under what circumstances have you disclosed the income? Have you come clean only after having been caught? Mere difference between original return and revised return will not attract penalty. In fact, there are certain decisions which I will share with Sharmaji which say that if you have had the time to file a revised return, then that is a valid return and would not attract 271(1)(c). However, if you have filed the revised return pursuant to having been detected, like Vandana Gupta was a case where after being detected, the assessee came clean. The court rejected her plea from escaping the 271(1)(c.
Yeah. Can the assessing officer or CIT appeal disregard jurisdictional high court on the ground that SLP has been filed before Supreme Court by revenue?
In what context? Will it be in the context of a settled issue by the Jurisdictional High Court?
Yes.
On a settled issue, there is a judgment of Maruti Suzuki where the court says, even though it was in a different context with regard to demands and refund, the court, however, observes that the AO can certainly, to keep the issue alive and for principle of consistency, take a view which will be in favor of the revenue. However, all the appellate authorities, according to me, would have to follow the High Court. And then if the revenue wishes, subject to monetary limits, it can agitate this case all the way up to the Supreme Court. So we often do that. We tell the concerned High Court that even though this is covered by the jurisdictional High Court, you may find that this is a covered case against us, and then we carry it to the Supreme Court. We would not be able to carry it to the Supreme Court if the AO at the threshold is prevented from taking this point, which will be covered by jurisdiction High Court. I hope that answers the question.
Mr. Kunal Reshamwala, would it be possible to briefly discuss decision of Philcom where you had appeared? Philcom judgment.
We are already running a little late. That will take some time. So maybe we'll reserve it for some other time.
Sir, do you think that iVenture Interactive, the fact of issuing 143(1) for earlier year on latest address is brushed aside lightly? Your thoughts on this?
I don't. You may have a point. The reason is this. There are income tax rules, if you will see, which require the assessing officer to follow as to how the notice will be issued. So if a notice returns unserved in the address provided for in the PAN database, then the very next item mentioned in the rules is that it should be sent to the address on which the assessee has filed his return last. So a lot of times I must candidly point out that a lot of what is held in judgments depends on assistance of counsels on both sides. So the assessee's counsel in this case, I'm not sure who had appeared, but ought to have pointed this factor out, that if the PAN address notice had come back unserved, it was a duty under the rules of the AO to serve it, then at least make an attempt to serve it on the address mentioned in the last file return. It was not pointed out, so to that extent, your observation is quite astute.
Sir, Mr. Ashwin Jain, can you throw some light on disallowance of employees' contribution under PF ESIC, because various courts have taken a different stand?
Yes, I think whether this deduction is concerned, will have to ultimately be considered in light of Dilip Kumar's case. I think a lot of these decisions are pre-Dilip Kumar, will have to be now considered after taking into account the principles of interpretation that have now been very well catalogued by the Supreme Court. So if you see that judgment, at least the highlights of that judgment, we will be able to, I think any court will then find these issues in favor of the assessee, because now, as far as Dilip Kumar is concerned, there is no doubt that deduction and exemption provisions will have to be interpreted in a manner which favors the taxpayer.
Sir, Mr. Hari says that whether revenue accepted the dismissal SLP in SSA Emerald case with respect to ambiguous notice, or whether still pursuing the issue in some other case.
To be very honest, I haven't come across any proceeding pending in Supreme Court on this.
Next question. Atisha Jain, during the inspection of file, it was found that reasons under 147 were modified by assessing officer. However, the same was not provided by the assessee during course of assessment despite request for the same.
So according to you, when was it modified? If it was modified prior to approval, prior to issuance of notice, there is no problem. If it was, and you are not then entitled to the prior reasons at all. However, if it was modified after the approval and after issuance of notice, then this would not be a correct approach, because the jurisdictional requirement is that the reasons should be there prior to issuance of notice. That is one of the jurisdictional prerequisite. But if the reasons were modified before the approval, before the notice, the principle is well settled, even in administrative law, that interdepartmental communications until a final decision is arrived at with the approval of the competent authority will not give rise to any legitimate expectation on the part of the citizen. So therefore, it depends on the fact scenario.
The assessing officer the assessing officer treated an income as royalty. However, CITP treated it as fees for technical services, whether it would tantamount to new source.
This again is a slightly vexed issue, because I have come across judgments on both sides which say that recharacterization of the same income may not amount to be a new source. So this may be very debatable.
Any landmark judgments on penalty leviable under section 270A? I think we'll skip it because it's a very general question asked.
No, and Supreme Court I haven't come across 270A. High Court there may be, but Supreme Court I haven't come across.
In NDTV, the reasons to believe were made on the basis of the DRP's order on the subsequent years and on the basis of complaints made against the foreign subsidiaries. The court upheld the reasons. However, was there really a nexus between the material on the basis of which reasons were formed in respect of the impunged transaction of the guarantee?
So it's a good question. It was argued during the hearing, and after argument, the court found that the assessment year. So the DRP's order was assessment year 2009-10, and the year of reopening, which is the subject matter of appeal before Supreme Court, was assessment year 8-9. And the court did find a nexus, which is why the court upheld the reasons to believe. The nexus being this, that the entire chain of company is also the same company which is the subject matter in the present assessment. I will restrict myself to that.
Yeah. Recently, the Finance Act has imposed limitations on stay at 20% of the demand for ITAT, whether it is justified.
It depends. Like earlier, the tribunal had a vast discretion, but these kind of provisions are really legislative policy calls. If you see on the indirect side, there have been over the years various percentages of pre-deposit, which is a mandatory requirement for filing an appeal. So, of course, there it is a lesser amount. Sometimes it's 7.5%. In some cases, scenarios, it was 15%. But this 20%, of course, is something which many assessees may find onerous. But it is something that cannot be questioned in terms of a policy call, because it's strictly in the domain of a condition for filing an appeal. And mind you, appeal is a statutory right. It's not a right which is dehors the statute or a independent right. So the parliament is always competent, theoretically speaking, to impose conditions for availing of such a right. Whether it's fair or not, I don't know. I can't comment, because in some cases it may be very unfair. in some cases where assessees who ought to make a pre-deposit, they don't, and in those cases it may be fair. So it may be a purely factual season.
So there is one more question on Philcom. Would you like to take it or should I skip it?
No, skip it.
Yes, that will take time actually. Because
Yeah. Whether reassessment made under section 143(3) read with section 147 would be valid when reassessment has been germane consequences of search having taken place at the place of the joint venture partner. Should not the order be passed under 153(c) of the Act?
In fact, this is very similar to the case that I discussed earlier, Vinod Kumar Gupta. You can look at the case of Vinod Kumar Gupta. Ordinarily, what you are saying is absolutely right. It should be a separate notice under 153(c), and it's worth making a challenge. Thereafter, if the court finds circumstances which permits such an exception, then bad luck. But otherwise, what you're saying is the rule. Vinod Kumar Gupta is the exception.
Sir, regarding Rule 27, if the claim is not made for judicial issue, can it be raised before tribunal? It has not been made earlier in CIT appeal.
Yes, now pursuant to Sanjay Sani, you can always make it. And there are very many judgments of Supreme Court which says a jurisdictional plea can be taken at any point. It can even be taken in the context of civil suits at the time of execution, provided you can prove that there was a jurisdictional defect.
With respect to fresh claim under claim whether 153A is for benefit of assessee or revenue, how do you deal with Sun Engineering where it dealt with fresh claim under section 147 of the Act?
Do you understand the question? I'm not sure of the question.
So the question is that under 153A, you've just answered that additional claim can be made.
Yes.
However, in Sun Engineering, under 147, they had said no fresh claim can be made. So are 147 and 153 on the same lines?
You could say that, but I think it's something worth taking a chance because of certain decisions where under 153A, the courts have held that the scope of the assessment can also be where the assessee can make certain claims where they've not made it. I'll share those judgments with you. Even though in the case of 147, there are some views that you can't make fresh claim. But on the other hand, 147, if you will notice, the jurisdiction permits you not only to go against those mentioned in the notice, but against all other aspects which you may not have mentioned in the notice. So it has to be tested, no? It is not yet tested. So we'll have to see how to assess that situation.
Okay. If jurisdiction issues are not raised before the CIT appeal, I think you've covered this.
Yes.
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 Sir, in case of search, where material is found in respect of another person.
Ashok bhai, that is also covered.
Okay. Your view on Supreme Court decision in case of...
no, I'm sorry, I think he's raising a different question. What he's saying is, can you do a 147 after search when you have 153C available?
Yes.
That is a different question. So to that, there are no direct judgments yet, but certain tribunals have held that when 153C is available to you, you can't do a 148 because of the non-obstantive clause in 153C. However, there is also one judgment you will see of the Delhi High Court called Raj Kumar Bhatia, where the Delhi High Court has said if even after search, the jurisdictional requirements of 153C are not met. I hope that answers your question.
Yeah. Your view on Supreme Court decision in case of Sisodia, additional evidence in penalty appeal for deciding quantum.
I follow your point, but you must also keep in view one basic principle that has been upheld in Supreme Court from ages now, that penalty and quantum proceedings are distinct in nature. They're legally distinct. If they are distinct, the question that I ask myself, and I leave it at that, is why can't additional evidence be taken? Because the nature of penalty proceedings is very different from quantum. The inquiry that is being conducted and what is required to be proved in the different in the proceedings, though both civil in nature, will give rise to different questions. So yes.
Yeah. So the next question is on iVenture Interactive, where they say that can section 124(3) have saved the judgment? Because assessing officers not having inherent jurisdiction on 122 issue notice, can't it be saved by section 124(3)?
Yes, it could have, but I don't think iVen Interactive was a case where inherent jurisdiction was missing. iVen Interactive was a case where, despite having jurisdiction, relevant jurisdictional notice was not issued. This was not a case where jurisdiction under 120 was missing. I very much doubt if a case of this nature can be saved under 124(3), where even without, suppose the AO, your jurisdictional assessing officer is in Ghaziabad and Gurgaon passes an order against you. I don't see any judicially trained mind accepting that.
Okay. So there's one question on 43B. I think you've already answered.
Okay.
Next, at what point of time the inspection of assessment records of assessing officer can be sought? At what point of time inspection of assessment records by
yeah. As a matter of abundant caution, one should seek it immediately upon receiving a scrutiny notice, and then see whether it's rejected, allowed, permitted or not, for what reasons. But as a matter of abundant caution, best is to seek before the AO immediately, so that everything is crystal clear.
Are there cases where CIT appeal has been held guilty of contempt of court for not following the jurisdictional high court decision?
Well, I haven't seen CIT appeal having been held guilty, but I am defending a principal commissioner of income tax in an exercise of power under 264 for not having followed a jurisdictional high court's decision, not in the sense of a precedent, but in the direct case of the same assessee where a matter was remanded and the High Court had directed the PCIT to dispose of the matter with reasons. When the matter was disposed by the PCIT, according to the High Court, there weren't good enough reasons and contempt was initiated, and I'm defending that presently. So that's the closest I've come. However, yeah. I must point it out to you, one thing, there are judgments of Supreme Court which say a quasi-judicial authority exercising powers and even assuming he or she exercises the power incorrectly and erroneously will not attract contempt. So there are decisions to that effect.
Yeah. Can assessee take benefit under section 292B if its return of income is treated as invalid as he has failure to furnish audit report along with return of income, but has maintained books of accounts and furnished profit and loss account balance sheet along with return of income? Audited accounts are furnished after return is treated as invalid.
You can certainly raise the plea of 292B. However, if you recall the provision of 292B clearly, it says, there is a provided that in effect and in substance, the action is in conformity with the provisions of the Act. Now, will you be able to show that not furnishing audited report is in essence in conformity with the provision of the Act when the rules and the provisions of the Act require you specifically to furnish audited account? So it may be a difficult proposition to canvass, but you can certainly make an attempt and seek 292B, because now you are furnishing it and department will have full opportunity of scrutinizing it.
So there's a general question on 115 BBE. I'm skipping that.
Okay.
The next question is post NDTV judgment. Should the assessee expect 147 notice based on additions in subsequent assessment years?
So post NDTV, this NDTV did not lay down any new law. NDTV has reiterated the law laid down in very many decisions, right from SSK to Justice Chandrachud's decision in the Bombay High Court of Anusandhan, Siemens, then even there's another Supreme Court decision of, I forget the name, Cadgill, I think it's called, which all of which say that subsequent assessment can be a basis for reopening provided new facts have come to light. So NDTV only follows that decision.
Yeah, sir, one last question. Reason recorded under section 148 notice was capital gain on sale of property, but assessing officer assessed it under section 68, same amount. Is assessment valid?
Same amount. See, so at the stage of reassessment notice, all that the AO is required to do, according to me, is raise the doubt regarding the amount that according to it, it has escaped assessment. At that stage, it need not, in fact, it is desirable that the AO does not make up his mind with regard to under which provision, with regard to under which, whether other amounts are involved or not, whether AO, SST has done something right or wrong. It is a notice broadly pointing out there has been escapement of income, that jurisdictional requirement is of escapement of income, and that it should be within the time limit, and if it falls within the proviso, to show failure to disclose truly and fully. So on this ground alone, maybe the assessment cannot be called into question, is my view.
Thank you, sir. We've